This sitting is resumed. Prior to the suspension, this Honourable Chamber was debating the bill to amend the Bail Act. To that we revert.
Speaker, I beg to move that you do not leave the chair and the House resolve itself into committee for further consideration of the bill.
Question that the Speaker do leave the chair and this House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Meeting the ayes have it.
This House is now in committee.
Clause 1.
Beg to move, Madam Chair, that Clause 1 stand part.
Question is that Clause 1 stand part. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Clause 2.
Madam Chair, I beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 3.
Madam Chair, I beg to move that Clause 3 stand part.
Question is that Clause 3 stand part. All honourable members in favour, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Pass.
Madam Chair, I beg that you do not report to His Honour the Speaker the passing of one bill in committee.
Question is that I do not report to the Honourable Speaker the passing of one bill in committee. All honourable members in favour, please say aye. Aye. All honourable members against, please say nay. Methinks the ayes have it.
Chairman of committees is reporting the passing of one bill in committee. Member for St. Joseph.
I beg to move, sir, that this bill do now pass.
Read a third time.
Be read a third time.
Question is that this bill be read a third time. All those honourable members in favour, please say aye. Aye. Those against, please say no. Meeting the ayes have it.
Beg to move the passing of one bill. That the bill do not pass and be cited the Bail Amendment Act of 2019.
Question is that this bill be now passed and so cited.
Ms. Motley. Lieutenant Colonel Bostic.
Aye.
Mr. Payne.
Aye.
Mr. Toppin.
Aye.
Ms. Ford.
Aye.
Mr. Prescott.
Aye.
Mr. Hinkson.
Aye.
Mr. Sutherland. Ms. Husbands. Mr. Abrams. Dr. Duguid. Mr. Weir. Mr. Ford. Mr. Thorne. Mr. Goodenedgel. Your Honor, Mr. Clark. Bishop Ackley. Mr. Griffith. Mr. Phillips. Mr. King. Mr. Jordan. Mr. Humphrey. Ms. Carroll. Mr. Strawn. Dr. Brown. Mr. Rowe. Mr. Speaker, 27 honourable members voted in favour of the bill, and therefore the bill is passed in accordance with Section 49 of the Constitution.
This bill is so passed and so cited.
You got something in the article, isn't it? Something in the article. You want it? Order number 15, sir. In the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Constitution Amendment Bill 2019.
Honourable Member for St. Joseph.
Mr. Speaker, this bill was last before this Parliament some months ago when we sought to introduce to the laws of Barbados a suite of legislation which would deal with the death penalty. Mr. Speaker, you no doubt recall that all save one of the pieces of legislation, all save one of the bills, was passed. The bill which amended the Constitution was passed in this chamber without dissent, but was rejected by the other place. Mr. Speaker, since that time we've had a number of meetings with the various individuals in the other place who had concerns about the Constitutional Amendment Bill as it was drafted. Sometimes, sir, you have to step back to go forward. In the words of a famous writer, sometimes when you think you win, you lose, and when you think you lose, you win. The importance of this bill, sir, is so that we could firmly put a new regime in relation to the administering of the death penalty in Barbados and remove it from being mandatory to being a matter for the discretion of the judge under our laws, so that the provision which concerned the independent senators was removed and the original position in the existing constitutional arrangement is being retained. With those words, sir, I beg to move that this bill be read a second time.
Question is that this bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Third time. I beg to move, Mr. Speaker, that you do not leave the chair and that this House resolve itself into committee for further consideration of the bill.
Question is that the Speaker do leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
Clause 1.
I beg to move that Clause 1 stand part.
Question is that Clause 1 stand part. All honourable members in favor, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 2.
I beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favor, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 3.
I beg to move that Clause 3 stand part.
Question is that Clause 3 stand part. All honourable members in favor, please say aye. All honourable members against, please say nay. Methinks the ayes have it.
Clause 4.
I beg to move that Clause 4 stand part.
Beg to second that.
Question is that Clause 4 stand part. All honourable members in favor, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Madam Chair, I beg that you do not report to His Honour the Speaker the passing of one bill in committee.
Question is that I do not report to the Honourable Speaker the passing of one bill in committee. All honourable members in favor, please say aye.
Aye.
All honourable members against, please say nay. Methinks the ayes have it.
Pedro, third time, third time, and then.
Chairman of committees has reported the passing of one bill in committee.
Speaker, I beg to move that this bill be read a third time.
Question is that this bill be read a third time. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Constitutional Amendment Bill Amendment Act 2019. You gonna ring the bell again?
Ms. Motley? Lieutenant Colonel Bostic?
Aye.
Mr. Marshall?
Aye.
Mr. Payne? Aye. Mr. Toppin? Aye. Ms. Ford? Aye. Mr. Prescott? Aye. Mr. Hinkson? Aye. Mr. Sutherland? Aye. Dr. Duguid? Should ring the bell now. Huh? Oh, you know. Okay. Ms. Husbands? Aye. Mr. Abrams?
Aye.
Mr. Weir?
Aye.
Mr. Ford? Aye. Mr. Thorne? Aye. Mr. Goodenedgel?
Aye.
Your Honor, Mr. Clark? Aye. Bishop Ackley? Mr. Griffith? Aye. Mr. Phillips?
Aye.
Mr. King?
Aye.
Mr. Jordan?
Aye.
Mr. Humphrey? Aye. Ms. Caddo? Aye. Mr. Strawn?
Aye.
Dr. Brown? Mr. Rowe?
Aye.
Your Honor, 26 honorable members voted in favor of the bill. Therefore means that the bill has passed in accordance with Section 49 of the Constitution.
This bill is so passed and so cited.
Order number 16, sir. In the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Constitutional Amendment number 2, Bill 2019.
Honourable members and Honourable Prime Minister.
Thank you, Mr. Speaker, sir. Yes, this is in the name of the Honourable Attorney General, but it really relates to matters pertaining to the Services Commission first and foremost, and to the judiciary. And these amendments, sir, are to be able to allow us to complete, from a statutory perspective, those things that are necessary, both one, to perfect the functioning of our administrative and legal systems, as well as to deal with issues in the operations of our judiciary which may be of concern to us. Sir, I don't intend to detain the House long in my opening remarks, and the Honourable Attorney General will give a fulsome explanation. But I do feel it necessary to speak to the Honourable Chamber about matters that are of grave concern to me. One, with respect to the administration of justice, and two, the desire to modernize our arrangements from a 1966 construct with respect to our services commissions as part and parcel of this government's determination to bring into the 21st century the functioning of the human resources of the public service of Barbados. And if I may start, sir, with the public service and come back to the administration of justice after, even though that is the first amendment in the bill. We, in our manifesto, sir, committed to bringing into reality and existence a modern functioning human resources framework for the public service of Barbados. I have said over and over that it is my considered view after almost 30 years in public life that the thing that separated Barbados from most other developing countries and most other countries in the Commonwealth was in fact, and has been in fact, the quality of our public service and the extent to which our public service has made this generally a country that is fair, in which things get done, and it is desirable for persons to be able to live in and to do their business in. Regrettably, there has been slippage over the decades, and we all know that. And it is largely because of a variety of reasons, but one of which has been a failure to grow to allow our systems to grow with the numbers of persons who are now currently employed by the public service, and therefore a failure to give that kind of dedicated attention to the individual development of those people who work in the service of the government of Barbados. Sir, if you may think of a pipe, however much you may want to do something, if at the end of the day the people who have to make the decisions, especially with a consolidation of power into the hands of a few people or one or two persons, it means that there is a continuous backlog, and simple things, simple but necessary things, are not done in good time or good order. The most egregious example of it is the payment of temporary workers. The most egregious example is the payment of temporary workers. We have for too long, and certainly for the better part of my career in this country, in this parliament, heard of examples of people who have worked an entire month, and then month after month after month, and in some instances 3, 4, 5 months, do not receive a single cent because the authority to process this person has not gone through. The notion of PSC 5 forms and PSC 6 forms continues to bedevil the process. Now, mercifully, technology will allow us and admit for us the ability to deal with this in quick time in a way that it didn't a few years ago. But even that will be insufficient. And we have a Public Service Commission, for example, and a Police Service Commission that effectively chaired part-time. They meet as a full commission, I think, once a week. They may have some subcommittees that may meet more regularly. But in truth and in fact, how do you treat to over 15,000, 16,000 people in the general public service with the limited numbers of persons and with the limited deployment of persons within the context of the Public Service and the Police Service Commission? In addition, Mr. Speaker, we have been for a very long time, and I think this goes back to the Ford Constitutional Review Commission, there has been a view that what was essentially only the Police Service Commission at the time of independence was insufficient to deal with those other elements of the service that are hierarchical in nature and disciplinary in nature. So you have customs, you have immigration, you have fire service, you have prison service, you have the government security guards, and all of them belong to a species of type of employment where hierarchy and discipline matter, and where there is almost a different approach to that type of employment than in the general public service, or, for example, the judiciary, or, for example, the teachers and educators. There has long been in our Constitution a recognition that we should establish a Teaching Service Commission, but it has not been brought into existence, even though the last government promised that it would so do. So that even in the recognition by the Constitution of different types of employment, there was already an admission that there should be different types of commissions. What we seek to do here today, first and foremost, is to establish a Protective Services Commission, Mr. Speaker, that brings in one place those persons who will help with the management and supervision of the terms and conditions and the career path development, or development path, of a number of people who belong in the same type of areas. The police, the prison service, the customs, the immigration, the fire service, the security guards. And Mr. Speaker, we believe that by so doing, that we should also create a chairman that can function virtually full-time, but with a wider panel of persons from whom to choose to constitute panels, so that instead of the commission having to meet and function fully only as a full panel, that we can get far more work done than simply meeting once or twice a week as happens now. Similarly, instead of relating to a broad general public service commission that is amorphous and has all of these persons, having taken out what will in effect be about 5,000 people for the Protective Services Commission, it is ultimately the intention of this government to also establish within the next 12 months or so, probably during the middle of 2020, because we are doing it sequentially, because we are also managing our fiscal affairs appropriately, but to establish a Teaching Service Commission, which will also be responsible for taking another 4,500 persons out of the Public Service Commission. But because we know that is where we are going, we have taken the opportunity at this point in time to change the Public Service Commission to what remains. And that is, Mr. Speaker, an administrative, general and professional services commission that will then deal with the remaining categories of workers, which should come out to be about another 6,000 persons. So what you see now, Mr. Speaker, is pretty much, and the Judicial Legal Services Commission is special because they deal with small numbers, so that really and truly they can be pooled together with the Protective Services Commission in terms of the Secretariat. But what you see is essentially 3 commissions that will have anywhere between 4,000 to 6,000 persons under their purview, which first and foremost makes the conduct of their affairs far more manageable than trying to manage 15,000 or 14,000 people at once and having the kind of backlog that precludes first and foremost payment to temporary officers, precludes appointments because you can't rationalize and do the things that you need to do in good time and good order, and to have the interviews and to have the assessments and to look at the performance appraisals. And all of these things suffer, but yet we say we want to live in a modern Barbados. There are other aspects, sir, that are not before Parliament today. And before the social partnership, we have a subcommittee on the structure of work and on pensions and on health care, because those are the big structural things that this government will engage in the next 12 to 18 months. Because we have to. And it is as simple as, how can we in 2019 force people to have to say that they're taking a vacation day or a sick day to do something for the family that's necessary to do? How do we make them a liar? When as big adults we all know that families have responsibilities that may not be vacation, they're not sick, but why can't we introduce the concept of loo days so that you can have up to 5 or 7 loo days? And you take your day now and you give it back later. Or you can take a half day and you give back the half day later. But you can't go above a certain amount. These are the kinds of things that the subcommittee in the social partnership is looking at, in addition, of course, to ones that I've already announced in the budget, like paternity leave, and other aspects of how we treat the families, and also how we treat to daycare for the needs of persons who work on behalf of government. Because your flexi time. In many instances, what matters is not watching somebody day in, day out, but are they working? And are they doing the job that is assigned to them? And do we have not a framework to be able to accommodate it, particularly with the level of rentals being as high as they are for government, and particularly with the incidence of sick buildings being what it is in government at this point in time? So all of these are part and parcel of an entire move to revolutionize the conditions under which people function as employees in the public service of Barbados. So we can't change it overnight, But I give this Parliament the assurance that we are going to work our best to change it month by month and year by year, because there are too many examples where the Barbadian public service looks exactly as it did in the year that I was born in 1965. And that cannot be. Similarly, sir, we also recognize that it is important that we put in place a framework that allows people to know that if you serve on a service commission, you have also to be accountable. And regrettably, sir, there are some examples to which I have referred in this honourable chamber already, which were totally unacceptable. I think, and I will stand on record for this, that the greatest blow to our police service came when a police service commission appointed persons who were junior officers to preside over people who were senior in the system and who would have previously reported to them. Sir, you could even make a case for a person who has retired at the top of the profession and retired 10, 15, 20 years ago, potentially. But when you bring somebody who is at a middle level, and we've seen it in not just the Police Service Commission, there's one other example of it in government, another commission, and you bring them and you put them at the top of the commission, and then give them the authority to preside over matters pertaining to discipline and other decisions on the functioning of officers who were senior to them when they were in the employ of the entity. It is a recipe for disaster. And Mr. Speaker, when I was confronted with this, I indicated it on both occasions with respect to the last Service Commission. And I'm not getting into individual names now. I think the principle is bad, because what it does is that it does not admit of persons being able to be dispassionate always. Now, it got worse, because we then found out that 2 commissioners of police, not 1, but 2, would have sent up recommendations for promotions only to have the Services Commission ignore them completely. In the first instance, ignore them in favor of recommendations from a deputy while the substantive commissioner was off, totally unacceptable. And in the second instance, recommendations of their own without reference to the ability to supervise and monitor these persons on a day-to-day basis, equally as unacceptable with respect to the functioning of the Commission. I believe that the government is now faced with a number of matters before the court and will have to pay the cost of that kind of behavior taken in the name of costs and damages, taken in the name of the crown of the country, in circumstances where we all know ab initio from the outset that you cannot behave in that manner because it is arbitrary and does not admit of the proper functioning of a disciplined hierarchical force. Mr. Speaker, the bottom line is that the amendments that are here are limited in respect of what they do. There is a change in terms of the numbers from 2 to 8 as being the number of persons who are entitled to be appointed besides the chairman, and that is to facilitate the multiple panels to which I've spoken, instead of having a 5-member commission that sits on everything. But if we want to be able to get a lot of work done, then we need to be able to have a lot of different panels working to be able to process the work of the various commissions. And, Mr. Speaker, I believe that this allows us to achieve that in good order. Similarly, Mr. Speaker, the consequential amendments that are here make use of the fact that the different departments that now fall, for example, under the Protective Services Commission. Hitherto, the Constitution only spoke about police. They now have at different sections, for example, Section 96, to include prison service, fire service, customs, immigration and security with respect to being able to remove and exercise disciplinary control over those particular officers now be invested in the Protective Services Commission. In almost every other instance, other than to broaden the class of officers and the name of the commission, structure of the commission, the purpose of the amendments and the nature of the amendments are almost identical to what would have existed before. Mr. Speaker, I want to mention the issue of customs just by way of example here, and perhaps simply because I met with customs today for over 3 hours, and I met with the Customs Department in circumstances where, Mr. Speaker, this department has been the victim of some of the worst form of what's the word I'm looking for now? That they have been ignored and they have been treated almost as if they don't exist, in spite of the fact that the Customs and Excise Department of Barbados once proudly had one of the best reputations in the region and the Commonwealth. Secondly, is absolutely critical to the collection of revenue, to the security of the country's borders, and indeed to the competitiveness of the country's sectors, both with respect to imports, and also exports. And Mr. Speaker, those 3 duties have to be carefully balanced between security, revenue, and competitiveness. But what do we have instead? A department that has not had 160 posts filled in more than 5 years. A department that has not had an appointed controller of customs functioning as its leader since the year 2006. And we are now in the year 2019. A department whose whole being was put on pause. A department whose youngest vehicle is 12 years old until recently. A department who has literally been ignored for God knows how long. And we have had reports done for the government of Barbados in March 2013 by the IMF, in September 2013 by CARTAC, in March 2018 before we became the government, and now again we've got the final report last month, which I am acting on because this is the first report that now comes to us and literally looks at everything. The customs legislation is 1963 legislation. I wasn't even thought of in that day, in 1963. But that is what governs the customs departments across Barbados, Customs Department across Barbados today. The Asecutor Plus Plus, we were the first department in the region to implement it. And now we are the last one in the region to have it, and among the last in the entire world to be operating it. The customs tariff that we use governing the importing of goods in this country and the rates to be charged there too is 2007. But since 2007, you had the 2012 and the 2017. And I'm happy to report to this chamber that I expect to receive in my hand within less than 2 weeks a draft 2017 customs tariff order in order for us to review and sign off to make the law of this country. And what couldn't be done in 10, 12 years has now been done in 4 weeks. Because when they told me, and I told you all this in the chamber already, that they're going to take 6 men to do the work. I said, well, 6 months to do the work, so it would make 6 men do it in 1 month. And that is exactly what they've done. The Asecutor world, this Parliament voted $700,000 towards the end of the last fiscal year, which finished this last weekend. And that should be in place no later than June. And I have committed today to meet with the unions, the 3 unions, and the Customs Department every month for the next 6 months until we get on top of all of the major issues in the Customs Department. Yeah. But perhaps the worst example of what I heard today was people who are called clerical officers in the Customs Department, but who dress in a customs uniform, do customs work, have been in that position for 21 years and are called clerical officers. Well, Mr. Speaker, we agreed today, and I'm happy to report to this Honourable Chamber that I created a new post as Minister of Civil Service today called Customs Officer 4. And I want to thank all three unions, the Barbados Workers Union, the NUPW, and the Unity Workers Union, that's Caswo's own, Unity, all three, for us sitting today and agreeing in the other place, not meeting as the other place, of course, to be able to correct wrong things. Because you cannot have people, and this is part of the problem that we had equally with Inland Revenue moving to BRA, that we had a lot of people who worked in clerical officer positions and admin positions, who did the substantive work, who understood the tax system. But once they moved them from Inland Revenue to BRA, they didn't have the qualifications in order to move, and therefore the institutional knowledge was ignored. Same thing in customs, and a number of people have left. How does the Barbados Customs Department produce people who are now top consultants in Africa, top consultants for UNCTAD in Jamaica, top consultants in Trinidad establishing an electronic single window system, top consultants for UNCTAD moving through the rest of the Caribbean? And we have problems here filling posts and doing basic training here. I am saying to you that this happens because we do not have the kind of dedicated focus on career development and the potential of our human resources that we ought to have as a government. And it is unheard of that a country that could be so otherwise committed to social justice and to the development of people could become so hamstrung and so hobbled by a public service framework that is decades old, that does not contemplate the reality of the 1980s and 1990s, far less the third decade of the 21st century. Mr. Speaker, it cannot continue. And I don't claim that my government knows the only way, but I know that we have the will to work with the unions and to work with the workers of this country to perfect the system that will allow them to be the best that they can be. And that is what these amendments are for. We accept that the simple creation of these new commissions will not be the only thing that is required. And that is why we are paying careful attention to the secretariats also that will have to support these commissions to make sure that there is a continuous flow and that it is a daily flow and that we move away only from the, look at them, the files that give you sinus trouble, and start to use technological processes that allow us to make decisions in short order and to use our time more efficiently and effectively. The PSC 5 forms and PSC 6 forms that trot up now and go in files and come up with a messenger and come up and boom, 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 boom. There has to be a more effective way to get authority to pay people. You can't have people work 4 weeks and then can't go to the supermarket and buy a carton of milk or a loaf of bread, and then to add insult to injury, when the trust 1 month and get the bread and the milk and the food, then when they go back the second month and the shopkeeper or the supermarket looking for the money for the last month, they got to tell them, I got to trust again, a second month, and then by the third month they got to trust again too. Or this time go and beg somebody in the family to help them out and hope that somebody got mercy on them, and you working 24/7 all the time. It cannot function anymore like this. And if we do nothing else as a government, for the public servants of this country, it is to be able to put to burial an archaic practice that does not admit of respecting the dignity of workers in this country. The Labour Party does not and cannot accept that as a form and standard of behavior, not in our 81st year. Mr. Speaker, I also want The Minister of Health is telling me that we are also inheriting a situation where doctors have not had their gratuities paid for 6 to 10 years. I had to ask the customs officers this morning if it was a plan to leave everything there for us to solve. Because I cannot believe that people could be treated in the way in which I heard today, cumulatively. And it is wrong. And like I said this morning in another debate, this is a country where we need to deal first with our needs and put our wants one side for the next year or two. Let us deal with our needs. Because if we deal with our needs, we are going to create a strong foundation upon which to build. And it cannot be that people cannot trust the word of government or cannot plan out their affairs because what government is supposed to do or has promised to do by contract, it does not do with respect to workers or suppliers or taxes, refunds, or anything. I mean, think of it. People for years, we are now about to pay out tax refunds for 2011 to 2016. People paid their taxes expecting to get back money. Not a cent. 5, 6 years. 7 years, 8 years. People work, expect to get a gratuity at the end of the contract. 5, 6 years gone, 7, 8 years gone. And then people have the gall to want to talk today now, having abused the rights of workers, abused the rights of suppliers, abused the rights of the policies insured by CLICO, abused the whole country. And in aid of what? What do we have to show for it? And what bothers me, sir, is that every time I think we have passed the worst of it, every time I think we've turned the corner, things keep coming up and files keep coming up. Letters out of the blue. Yesterday I learned of another contract signed, giving a company out of Germany the right to determine whether the water authority can enter into photovoltaic farms. And this is signed, and the water authority is yet to show me and cannot find the board resolutions authorizing the signature of this contract. Mr. Speaker, every time I think I pass the worst, the member for Christchurch East can tell you, because he was with me when I heard yesterday, and I'm saying to this country that our only way to be able to move forward is to first focus on the essentials. And part of the essentials for this government is respecting the dignity of workers across this country. So that is why one of our first duties when we became a government was to give the public servants a 5% pay increase. Having not received an increase in 8, 9 years, last year when we gave it to them, I can't say that we can do it this year again, probably can't. But the bottom line is that what we did instead was to be able to start to ease the level of income taxes paid by workers in this country below a certain level, giving the reverse tax credit to workers who now earn between $18,000 and $25,000, who even though they don't pay VAT on food and VAT on transport and VAT on financial services and VAT on medicine, when they do pay VAT, we say, look, take back that $1,300 when the year comes to help you with the duties that you had to pay in VAT. And for the people earning between $25,000 and $35,000, or to put it another way, the people earning between $2,000 and $25,000 and $2,800 roughly, $2,085 and $2,800 roughly, that even though you may pay tax monthly, next year, April, when you file, you're going to get back every cent in income tax that you pay, because we feel that that compensatory income credit will help you to live in this country in the absence of the other things that we would like to do, like across-the-board wage increase. Mr. Speaker, let us focus on the essentials. And if we do that and stay the course, I know, sir, that we will be able to produce a strong, competent, competitive public service that will rank among the best in the world. And this structure of commissions is intended to allow us to achieve that, largely because it makes the numbers of persons that the commission will deal with, each commission deal with, manageable. And it then allows us to be able, I hope, to be able to sit down with categories of workers. And it was the program that we have to make Barbados a training campus for the next 4 years, to be able to deliver the quality of training that will allow our workers to go anywhere and sell their services at a high dollar, a high rate in the future. Mr. Speaker, this amendment, however, also deals with a very troublesome issue that we committed to dealing with before the election, and that is the delay in the delivery of judgments in our justice system. Deals, all right?
That's fine. We're going to change it.
Right. Mr. Speaker, the only amendment, therefore, that is here for this is that previously under Section 84, a judge may be removed from office only on the basis of inability to discharge the functions of his office, whether from inability of body or mind or any other cause, or 2, for misbehavior. But we now today add, sir, for delay of more than 6 months in delivering judgments. And I believe that the amendment has been made to make sure it is plural, in delivering judgments. And why, Mr. Speaker? Do we know that when a judgment is not delivered, that the Crown is potentially at risk of damages for the failure to ensure that the constitutional right to due process is delivered? And there are too many instances of people both in the criminal and civil realm who are awaiting decisions 5 years, 7 years, 8 years, 10 years. All of the resources are locked up. In the cases of personal injuries or commercial matters, companies cannot make decisions to move forward. In the case of victims in personal injury matters, persons are out of pocket. They've paid doctors, they've paid for reports. They cannot work to full capacity in many instances. Their earnings are down. In the case of the insurance companies, contingent funds, money lock off, and therefore the premiums going up because the company is not being as effective and efficient as it might otherwise be. In the case of criminal matters, we saw the worst examples of it as we discussed the bail amendments today. How do you have people charged with murder, Mr. Speaker, as you well know? 2013, 2014, 2015, not a drop of evidence. And effectively the sentence of the court, which is available to the court, rendered nugatory before a scintilla of evidence is led against an accused person for a murder charge, because you cannot apply the sentence so long as the person has been either on remand or awaiting trial for the length of time that they've been doing. And then the worst example, you get bail, and the person comes back out and commits another murder, God forbid, as has happened. Mr. Speaker, we cannot continue. You know, I remember when the prison burnt. The person who is responsible for drafting our Constitution, who is no longer with us, but who was a distinguished Barbadian, recognized not just by us, but by the region and by the United Kingdom, Sir Roy Marshall. And life is so funny and so short. On that occasion, we took the then leader of the opposition, a member for St. Michael Northwest, as he then was, who is now our ambassador and economic advisor, and we took him and members of the opposition to Harrison's Point in order to visit the new premises that we were going to relocate the prisoners to. And I will never forget on that morning, Sir Roy addressing the press. And Sir Roy said then that the difficulty that the Commonwealth Caribbean had faced is that upon the granting of independence, we focused on the most patent needs of our people: housing, education, healthcare. But that there were some things that we didn't focus on in the first generation of independence that are now catching up to haunt us: the administration of justice, our prison system. And he mentioned one or two other things. And it hit me then that he was absolutely correct, that we were effectively running a 19th century criminal justice system with a 19th century prison, with a 19th century police force, established in 1838, the third oldest in the Commonwealth, with a 19th century psychiatric hospital, and that because they were unsexy, they did not command either the attention or the claims on the public purse that they ought otherwise to have done, and that they had so reached a point of stress that they were now beginning to collapse before our very eyes. Now, Mr. Speaker, I understood then, as I did for the last decade, that if we don't fix the administration of justice in our country, modernize our police force and our prison system, our customs department, our immigration system, that we will literally be the architects of our own demise, because we no longer have the capacity to deliver the things that we ought to be delivering for the people who rely on these particular services. Mr. Speaker, I came to the bar in December 1988 in Barbados, in England in July 1988. I was 21 years old. And I entered a bar that was much smaller. I saw a law court system that generally works still for people, and that was regarded as one of the best in the region. And regrettably, sir, we have now a system that is not delivering for us, and which has been the subject of negative comment by our highest court in the land, the Caribbean Court of Justice, for failure to deliver judgments on time and in quick order. Mr. Speaker, we take no delight, either here or as we then were on that side, when the Caribbean Court of Justice could have referenced Barbadian judges negatively with respect to the delivery of judgments and ensuring access to justice in this country for litigants or accused persons. And as a result, sir, like other countries in the region, I believe Guyana is foremost in it, we have taken a decision as a cabinet and bring now before this honourable chamber to expand the reasons for removal of a judge. And I hope never to ever have to see the utilization of this limb, because I hope that it will ensure that we no longer have judgments outstanding for more than 6 months, criminal or civil. But we include today a ground for removal from office if there is delay of more than 6 months in delivering judgments. All that does is to spark the process, because you still have to go through the normal process where the Prime Minister, in the case of the Chief Justice, or the Prime Minister after consultation with the Chief Justice, or the Chief Justice after consultation with the Prime Minister, can advise, in this case, Her Excellency the Governor General, that there is need to remove a judge from office. And if that happens, then the normal process that is already enshrined in our Constitution from 1966 which is the establishment of a tribunal, kicks in then. So that this does not allow any of us, Chief Justice, Governor General, Prime Minister, to go and say you have to go. It just simply says that this can be a ground to trigger the process for the establishment of a tribunal in order to determine whether the person is in fact in breach of these provisions here captured at Section 84 of the Constitution. Mr. Speaker, sir, this Parliament, you, me, all of us in here are accountable. And we are accountable at the foot of democracy to a process that cannot exceed. We used to think commonly 5 years. We now hear 5 years and 90 days. I give this House the assurance that I can go back to say 5 years. But all of us are accountable. And every job in this country has to deliver what it promises to deliver. If not, the system does not work. It doesn't work. And we have to find, therefore, a way to make our judiciary and our administration of justice work for us. If not, the average man or woman in this country will feel hopeless that they cannot access justice and cannot get it when they most need it, particularly where there's an imbalance in power. There's an imbalance in capacity. And this government is committed, as we are to respecting the dignity of the worker, we are equally committed to respecting the sanctity of the rule of law and the administration of justice in a manner that matters and means something to ordinary people. Don't tell me to go to court and file a case if when I file it, I cannot get a judgment under 7 years or 10 years in this country. Don't tell me that I will be charged in this country and no evidence will be proffered against me for 3 years or 5 years, because it means that the system and the society will turn on itself. And God forbid the worst examples of that, where people take their own future into their own hands, starts to happen in a small society. We contend, sir, that bullying is wrong at the level of the international community. Having people unequally yoked at the level of the international community is wrong. It is equally wrong within our domestic shores and within our communities. And Mr. Speaker, sir, I therefore want to commend, and you may say that it's two totally different things in this bill. It is, in part, but it is an amendment to the Constitution on two of the most critical components facing our ability to administer, one, justice in this country, and two, to develop the human resource potential of our public service in this land. Sir, this is by no means meant to be a commentary on the state of the 1966 Constitution of Barbados. There was already a Ford Constitution Review Commission, and there was already a draft constitution which I worked on, a draft Republic of Barbados Constitution, which I worked on as Attorney General with the same Sir Roy Marshall and Professor Patchett, who was the first Dean of the Law Faculty at Cave Hill, along with the then Chief Parliamentary Counsel, the eminent Professor Mr. Simeon McIntosh, who is regrettably no longer with us on this earth, but who was author of one of the better constitutional texts of the Caribbean, and indeed a gentleman who was given the opportunity to come to meetings and may well have lost his way along the way since coming to those meetings. But we must not assume that only Saul turns to Paul. Regrettably, sometimes Paul turns to Saul. And in that case, we have to take responsibility for his becoming blind, having attended those meetings. After those meetings, he became blind in a way that is unfortunate. But without prejudice to his attendance and presence, it was a strong committee. There were 2 or 3 matters that still needed to be decided by the then Prime Minister, and we need to decide them. and that relates to the Integrity Commission. Because if we establish an integrity commission, in my view, it ought to be part of our Constitution, in the same way that the Electoral and Boundaries Commission is part of our constitutional makeup. I say only these things now to alert to the House that the matter of the modernization of our Constitution is still in the hands of the Honourable Attorney General. But we could not, in 10 months, deal with the whole Constitution. But equally, we could no longer delay these urgent and important components that need absolute modernization if we are not to bring hurt and difficulty or continued difficulties to too many Barbadian workers and to too many Barbadian litigants and accused persons with respect to the administration of justice and the conduct of the management of our human resources. Mr. Speaker, sir, I therefore commend these amendments to our Constitution to all honourable members in this chamber and pray that it will enjoy the full support of this House as we have done thus far, recognizing that this also helps tangentially the police in particular, who are urgently, and customs, both of whom are urgently awaiting strengthening of their structures, of hierarchical structures, in order to be able to play a more efficient and effective role in law and order in this country. I've said that we need to be able to create a few more posts at the high level of the Commissioner at the high level of the Royal Barbados Police Force, and we need to do the same thing with respect to the Customs and Excise Department in order to allow it to be able to play the effective role that it has to play to secure our borders. And I therefore look forward, sir, to the support of this honourable chamber in these amendments to allow us to carry on with the job of securing this country and making it a more productive place for the public servants to work in Barbados. Thank you. Thank you, Moser, that these amendments be read a second time.
Wait a second.
Honourable member for St. Peter.
Thank you very much, Mr. Speaker. I too want to support this bill that is before this honourable chamber this evening, a bill that speaks of amending the Constitution, but specifically to the establishment of certain service commissions, as well as the amendment, as the honourable member for St. Michael Northeast would have referred to, the one that speaks to judges and provision, well, adding a provision under which they can, a motion can be triggered for removal from office. And I want, Mr. Speaker, to begin where I normally begin, because I think it is important to repeat and to keep repeating, especially in situations when we're talking about people and the management of workers. I think it is important to continue to remind us and to remind Barbadians that this party, the soul of this party, is with the struggle of workers in this country. This party was founded out of an understanding that people needed to be looked after. The lot of workers needed to be improved so that their terms, their conditions, the environment in which they worked needed to be addressed, needed to be improved, because our founders saw those workers as human beings who deserved better. They deserved to be treated as human beings. And so, excuse me, Mr. Speaker, once that was recognized, Then we moved to organize workers. And those who led this party also, in their quest to organize the workers, set up a separate organization, which they also led on a parallel track. And they did that because they recognized that if workers are to be developed, then structures need to be put in place to foster and to encourage that development. Structures that would speak specifically to the need for workers to be developed, and that would speak specifically to what measures needed to be put in place to facilitate that development. Because, Mr. Speaker, these things do not happen, as we say in St. Peter, just so. There have to be structures put in place to allow for the facilitation of workers' development. And so the formation of institutions such as workers' unions, and I think the Barbados Workers' Union would have been formally established in 1941, a few years after the party that I'm a proud member of was formed. But that was done as not the start, because workers had been, there had been attempts to organize workers before. Another great son of the North, Mr. Charles Duncan O'Neill, also participated in a process to organize workers. And workers, the Working Men's Association, because it was understood that organization was needed, it was understood that structures needed to be put in place so that workers could be organized, and so that what was necessary for the improvement could be adequately carried out. The programs could be put in place by these organizations that were fostered and that were developed. And once there are organizations developed, Mr. Speaker, then there needs to be adequate leadership in these organizations, adequate management of these organizations. And outside of organizations that are set up specifically to agitate or to promote the improvement in the welfare of workers, the organizations that workers are already a part of, where they work, those organizations, if they are going to be part of the process of improving people, also need adequate leadership. And I want to suggest to you, Mr. Speaker, that most of the industrial relations issues, most of the negative aspects of the relationship between employers and employees is a result of persons in leadership either not being sensitive, not being sensible, or being just totally callous about the people who they've been charged to lead and to manage and to develop. But management, proper management, effective management of workers is absolutely necessary if workers are going to be able to perform at their maximum. If a person is to be able to perform, to work, and to give of their best, operate at their full potential, then those persons need to be properly managed. Management at the level of the workplace needs to be such as to encourage workers to produce their best. And Mr. Speaker, we live in a society, we live among people, we are people, and I want to suggest that most of us want to do our best. We want to feel fulfilled, we want to feel accomplished. And so it is incumbent upon those of us in this chamber, those of us elected to lead in the country, to ensure that structures are in place, effective structures that would allow for the development of people and allow those persons, workers, to produce at their full potential and to feel as though they are fully a part of the process of nation building. The management of people in our society is no longer about keeping records, about writing up warnings, about simply engaging in disciplinary activities. This is now 2019, not 1919. We are, as the Prime Minister often says, we are on the cusp of the third decade of the 21st century. And so the process and the procedures involved in managing workers must evolve with the times. We are at a stage, Mr. Speaker, where people working must be recognized as persons with the potential to contribute. They must be encouraged to contribute. Training must be put in place to allow them to develop their skills, even sometimes to recognize what their aptitudes are, because often there are people in workplaces who are unhappy, not necessarily because of their workmates or of their supervisors, but because what they are doing is not really what they enjoy doing. But part of the role of those who manage people is to help those who are working, who are part of the organization, to recognize either that this is something that suits my aptitude, suits what I like, or maybe there is something else that will allow you to be fulfilled and to feel accomplished every day that you come to work. That is part of what managing people is all about. And so as we seek to develop structures to manage workers in this country, we have to recognize that as we manage people, we have a significant responsibility in helping to guide persons, to allow them to feel accomplished and to deliver on the potential that lies within every one of us. The Honourable Member for St. Philip West spoke earlier about holding babies and looking at them, and one baby could be a Prime Minister and the other one could be a serial killer. But at that point, you have in your hands a being, a human being who can be molded, who can be fashioned, who should not be written off. And I want to say that even though I made reference to babies or young children, that once a worker is part of an organization, then those who lead the organization have to recognize that they have a similar responsibility, not to treat the worker as a child, but to see themselves as part of a process to allow that worker, that human being, to go down the right road, to realize their potential, and to make a contribution not just to the business or the company or the organization, but to make a contribution to themselves, to their families and their relatives and dependents, and ultimately to make a contribution to the development of the country that they are a part of. Management of people is about developing people. I want to insert here that there are a number of people, both in the private sector, but I've also realized in the public sector as well, some under the guise of being human resource advisors, they seem to see their role as that of tormentor-in-chief. And some of them seem to think that they have been engaged to make people's lives miserable. And I want to say to them, and to those who have engaged them, and to my colleagues who in some cases have oversight over them, that is not how the Barbados Labour Party operates. The Barbados Labour Party is a party that, I don't want to say we are partial, but if we were to be partial, we would be partial to workers. I would want to say that we are fair, and that we believe that organizations are created to achieve certain objectives. Businesses are set up to earn a profit, but the people who constitute the bedrock of all these organizations must be treated fairly, must be treated with dignity, must be treated as though, well, they must be treated in recognition of the fact that they have value in and of themselves and that they have value to contribute to the organizations. And so they are not there to be mistreated. They are not there to be looked down on and treated as though there are some other resource like machine or building or plant or something like that. That is not how we operate. I'm saying, I don't send warning shots. I'm just saying to these people who, and I don't like using religious references in these instances either. So I'm not going to refer to them as popes. I'm going to refer to them as a common people. I want to refer to them as misguided people who feel they're McGuffies. But I want them to understand that they are in place to facilitate the development of human beings, to facilitate the development of people. I also want, even as we speak about the establishment of service commissions, essentially structures for managing people, to speak to those organizations who believe that they do not have to follow the laws of this land. Unfortunately, in 2019, at the beginning of the 4th month, there are still people in Barbados who do not believe that they have to give 3 weeks or 4 weeks vacation, according to the law. There are still people, some employers in Barbados, who do not believe that they have to give persons notice of disciplinary hearings. There are still people and organizations in Barbados in April of 2019 who do not understand that a person has a right both to representation or to be accompanied by somebody in a disciplinary hearing. There are still people and organizations in Barbados in April of 2019 who do not believe that they have to give reasons for termination, or that they have to give what we call traditionally a green paper. There are, in essence then, Mr. Speaker, still bandits in Barbados long after I was a child and bandits were banned. There are still people who believe that they can treat people as just things to be used. This Barbados Labour Party don't go down that road. This is a party that believes in people, that respects the rights of people, and that believes that workers, those who contribute to organizations, must be valued, must be respected, must be taken care of. And as a party, we lead by example. And so when the Honourable Prime Minister speaks to, or spoke to, recognizing that public servants did not get a pay raise for 8 or 9 years, one of the first things this government did on coming to office was to give a pay raise. As a matter of fact, we went so far in the campaign as to say if within X period of time we cannot agree, we will go ahead and give people more money. Because we believed strongly, to the point where we took maybe an undemocratic approach. But we believe even if we have to force the money in your pocket, that is what we're going to do. The Honourable Leader of the Opposition is looking at me, he remembers well, because he was one of the persons then with us who felt very strongly about that, and who agreed that whether or not the unions agreed, we would, if we had to force the money into the pockets of public servants, we would have done that, because we believed that they deserved an increase. And so we did it on assuming office last year, around the middle of the year. This government, Mr. Speaker, also is not above talking with people, engaging in conversations with people. And so the Prime Minister would have met early in the morning. Those of us who work with her know that she is not necessarily an early morning person. She doesn't like to go to sleep at night. She will work all night. The Honourable Member for Christchurch East Central is very familiar with that. Poor fellow. But she went early in the morning to meet with workers of the Sanitation Service Authority. We've also met with workers of the Transport Board, because we believe that workers are people. Workers are to be respected, and that respect must happen from the highest levels. Today, we met with Customs. We heard some stories. I don't want to call them horror stories, but we heard some concerns. And we were able to hear those concerns because we have determined, because it is in our DNA, that we will listen to workers. We will show respect for workers. And some of those workers told us, you could see the relief on their faces. They've not had a situation in the past where people at the level of Prime Minister would sit and listen to their issues and commit to the resolution of those issues. But, Mr. Speaker, that is what good management is about. That is what the Barbados Labour Party is about. That is what our brand of leadership and management is about. We respect workers, we value workers, and we engage with workers. Structures are needed if the management of workers is going to be effective. And I started to speak to the fact that as a party, we put structures in place as early as the 1940s. But times change. And so as we move forward, as we develop, and that is the reason why we have indicated, Prime Minister has indicated that amendments such as these are not to suggest that what happened at independence in terms of the Constitution was in any way deficient. But, Mr. Speaker, we are now over 50 years removed. When that Constitution was put in place, I was not born. I was not thought of, because the two people who came together to produce me had not yet met. And so I could not have been contemplated by definition. But it is not to say that there was a deficiency in the Constitution. Times have changed, and so the organizations, the structures, the mechanisms that are to be put in place, or the mechanisms that are designed to manage workers and manage workers in the workplace have to change as times change. And so this amendment speaks to the creation of an Administrative, General and Professional Services Commission. It also speaks to the establishment of a Protective Services Commission, and the Constitution already speaks to the Teachers Services Commission. And, Mr. Speaker, even in small organizations, organizations of 100, 200 persons, there are fully staffed human resource departments. An organization, the Honourable Member for St. Michael West Central is probably better able to say this than I am, but an organization of 200 or 250 persons will probably have a human resource manager and 1 or 2 human resource officers, because it is recognized that when we are managing people and everything that comes with managing people, because, Mr. Speaker, we are complex beings. We are not boxes, fridges, stoves, buildings. We are complex beings. And when we are managing people, then we have to have the adequate resources to manage those persons. And with a public service of thousands of persons, it is now almost unmanageable how we would deal adequately with these thousands of persons with the existing structure. It is just not possible anymore, no longer possible. And so having to separate the commissions or segment those workers who fall into the 3 different commissions also allows for a certain degree of specialization. And I spoke a bit to specialization when we debated the matter of increasing the number of judges. I am of the view that with specialization comes greater ability to manage. And so if you are charged with managing teachers only, for example, then you have a greater opportunity to understand the nuances of the profession, to understand maybe in a more granular way what takes place in teaching and learning institutions, how they're structured. There is an opportunity to gain a more in-depth knowledge of what happens in those particular areas of endeavor. And I'm of the view, Mr. Speaker, that with that improved knowledge, it allows those who manage to be more effective in their management. And so I fully agree that there should be a Teachers Services Commission, that there should be a Protective Services Commission, because one of the issues that our country is grappling with, and not just this country, one of the issues that the world is grappling with is the issue of safety and security. So whether it is a young man shooting somebody in Sheraton or ISIS somewhere in Syria, there are issues of security all around the world. The things that impact security and those who work in the areas of security need special attention. And I believe that as time continues, that need for special attention will not diminish. Because just as large countries develop new weapons of war, people in small countries develop new ways of attempting to destabilize, infiltrate, and so those who manage persons who are on the front line, those who are exposed, they also need to be focused. And so there is a need for that special commission, that special services commission that focuses on the protective services. The role of a government, Mr. Speaker, is to protect me, you, all the people in St. Michael Central and St. Peter, and those who we've invited to visit our shores. A government is charged with securing a country. And so a Protective Services Commission is a must. It is a development whose time has come. We are a responsible government, and as a responsible government, we sat. I'm speaking now specifically to how we manage our people. We heard today, and I know this is replicated across the service, but we heard today of clerical officers who have been doing customs officers' work for one person, I think, for over a dozen years, but still classified as a clerical officer. Those things are not right. They're just not right. And so the Honourable Member for St. Michael Northeast, the Honourable Prime Minister would have indicated that she agreed, as the Minister of the Civil Service, of the Public Service now, agreed today that we would establish a position that allows entry level. Previously, the lowest position would have been Customs Officer 3. But there are persons now who are moving from clerical officer because they're doing customs work already. And so we've created the position of Customs Officer 4. That position will be covered in the explanation in this bill, the explanation that speaks to those people who are called customs officers, whether they're leaders, the controller, the deputies, or customs officers. Because if they are to be included in this amendment, in this bill, then they need to be titled customs officers. If they are doing customs work, as they are doing, but they are called clerical officers, then they are not covered under this amendment. And as a party, as a government that is really concerned about workers, their welfare, and just essentially a government that wants to do good by people, we have determined that because they've been performing the duties of customs officers for so long without any negative references, government has determined, and the minister responsible, the Honourable Prime Minister, has determined that it would only be fair to these workers to include them in this new structure that allows for better management of them as workers in the workplace. That is why they will be included either as customs officers 4 at the entry level, those who have been doing this for quite a long time, those who have been doing it for a long time, and the Honourable Leader of the Opposition is asking about pay. I just want him to know that his senator was present and is fully seized, and if he hasn't informed his leader, maybe he should be sanctioned. But I know he will inform me in due course. It was just earlier today. But we will do good by the people. I want to inform the Honourable Member for St. Michael West, and I want to inform you, Mr. Speaker, and I want to inform Barbados. We will do good by people. Not everything we want to do can be done immediately. And we have been clear and open with those customs officers with whom we met today. It is important, though, that even before we discuss the remuneration, which will be discussed, we need to make sure that they are covered by this commission, this Protective Services Commission, because this commission will assist in properly managing them as workers. And that was the reason why we have created the new position. But before I heard the aside that we are not supposed to hear, I spoke to Customs Officer 4. But by doing good by people, by the workers of this country, we recognize that there are persons who have been doing the duties, performing the duties, for 10 years or even more. And it would be unfair to put them into customs officers' bracket at the same level of a person who is now being appointed straight from application. And so it is possible, because I am not here now able to make a commitment, but we have discussed, and it is possible that some of those persons will move into the system as Customs Officers 3, as opposed to starting at Customs Officers 4. So that a person who's been performing the duties properly for 12 years will not start at the same position as a person who is now starting out or who has been in for 6 months or 1 year. The unfairness we are trying to get away from, the mismanagement of people we are trying to get away from. Essentially, Mr. Speaker, out of our respect for workers, in everything we do, we have been engaging the workers and their representatives. I just want to say this before I finish. The Honourable Prime Minister would have said that all 3 unions were present, because we recognize that there are 3 unions. And so we do not, even though the leader of one of them may be a little rough with us sometimes, we don't play politics when it comes to the welfare of workers in this country. And so even if the leader of a union will chew us up and spit us out, once that person is representing people, we will engage with them. That is how we see workers, and that is how we respect workers. I want to say that the public workers that I have come into contact with over the past months are in the main willing to work, ready to work. The customs officers we spoke to this morning are patriots. They are saying to us these are ways that we can make things better. And they're not asking for a lot. They're just asking to be valued. They're asking for their views to be heard. They're asking to be treated as human beings. And so, Mr. Speaker, we have committed to providing the real leadership that our workers have been longing for many, many years. We are going to do it, and I want to say something very, very briefly, Mr. Speaker. I know I've gone over.
You know what, you're very cognizant of that, sir?
Yes, I'm conscious, but I want to say something. The Honourable Prime Minister mentioned, she spoke to the issue of the judges and the matter of the commissions being different. I almost forgot, but I want to say, and I'm not correcting the Prime Minister, but I want to say that anytime you set performance targets, that is fully within the ambit of people management, human resource management. And so I see the inclusion of the 6-month limit for judges to deliver a judgment as fully part of the managing of the workers of Barbados, because judges are workers as well. And so if we are going to hold them accountable, we have to tell them what the standards are. After this bill is passed in both places, they know that they have no more than 6 months. So that if there's going to be any disciplinary procedure afterward, they know up front. You cannot discipline a person if the person does not know the standard. And so this bill, all facets of it, speak to managing people. And as a government and as a party, we are committed to people, we are committed to their development, and we are committed to putting the structures in place that will allow them to reach and realize their full potential. And with those few words, Mr. Speaker, I commend this bill to this honourable chamber.
Honourable Leader of the Opposition.
Thank you very much, sir. Now, this government, Mr. Speaker, as we all know, has made much ado about improving business facilitation in Barbados. They have projected that as one of the principal planks of their program for growth going forward. You cannot speak, in my view, to the matter of business facilitation without addressing many of the inadequacies in the public sector with reference to the service it is anticipated to render to its much varied clientele. And therefore, it would be significant in that context to address any deficiencies in the overarching administrative structure with reference to the public service. And that is how I therefore view this matter that addresses what we have known as in the past a Public Service Commission and the intended change to Administrative, General, and Professional Services Commission. I think as well, Mr. Speaker, we need to ensure that the system under which we operate also yields a better facility to our protective services. As the last Honourable Speaker has said, protection is one of the primary responsibilities and obligations of the state management to its citizens. And therefore, we cannot mess around with the business of the protective services. We are all aware of some of the shortcomings in the past, several of which were alluded to by the Honourable Prime Minister when she spoke. And therefore, we have to improve the way services are offered and provided through agencies and entities such as the customs, the prisons, fire, the police, immigration, etc. And if this measure is intended to yield that better facility for the functioning of those entities, then I am very much agreeable to that. You cannot mess around with the business of protecting our gains, protecting the liberties of our people, protecting our borders. Socially, politically, economically, we advance, but that has to be in a context where the services charged with the frontline responsibility of ensuring protection are properly administered and therefore properly positioned to serve us. The Honourable Prime Minister made illustrative reference to the matter of PSC 5s and authorities for appointments and payments of people. And I used to be very familiar with that type of unfortunate situation with reference to the prison service, where for months people have to go without pay because there's the absence of authority. People operating in a supposedly supposed environment, charged with a primary responsibility for securing our interests, and yet they were exposed to temptation. They were exposed to that type of indignity, Mr. Speaker, and the security of the country, therefore, put in a place of peril and jeopardy. So I would want to say at the outset, I support the measures to amend the Constitution such that we can provide for more effective administration of the frontline security services in Barbados, as well as for the administration of the public service by devolving some of the responsibility from the now established Public Service Commission to an administrative, general, and professional services entity and a protective services entity. But, Mr. Speaker, I think the more controversial part of this bill to amend the Constitution before us would obviously relate to an attempt to provide further for the possible removal of members of the judiciary. Now, not so very long ago, the Caribbean Court of Justice, and I think it was a repeated instance, was fairly scathing in its critique of the Barbados judicial system.
Honourable member, it has become a norm. It has become a norm.
And that's the point. And that's the point. And it was characterized as being a system which was fraught with inordinate delay. They cited the inordinate systemic delay, and they made reference to particular cases which went unfinalized, if I might use that term, in terms of full decision for years and years, inordinately long time. The surprising thing was that the reaction of the then government, vocalized in the words of the former Honourable Prime Minister, was pretty dismissive of that critique. And I had taken note of that, and it constituted a serious concern to me, because if the CCJ criticizes in that fashion your judicial culture as being an inordinate systemic delay, characterized by inordinate systemic delay, then that should be cause for concern. And to be dismissive of that was seriously a concern to myself. All of us in this chamber, perhaps you would be among those persons more so who would be immediately faced with the challenges constituted by those delays, and you would have suffered some of the frustration.
And continue to suffer, sir.
And continue to suffer some of that frustration on behalf of your clients when we are faced with a system that does not work. Is it therefore that we must interpret the attempt to give an added stipulation potential removal of judges in this regard, in this context? Should it be evaluated with reference to that inordinate systemic delay characteristic of which we spoke? I think we must. Now, Mr. Speaker, dysfunction at the level of the court strikes at the heart of justice, which is one of the principal planks of our political, social, and human development. Dysfunction at the level of the courts strikes at the heart. Now, that kind of phrasing is fairly familiar. In recent days, a banking official has so characterized this government's efforts to restructure its debt with reference to the banks as an axe striking at the heart of the bank. An axe striking at the heart of the banks in Barbados. That too, Mr. Speaker, was responded to in dismissive tones, not by anybody who legitimately is located in this chamber, but that also concerned me, that you could have those types of dismissive tones employed and those types of dismissive remarks made in response to a concern expressed by a banking official with respect to the impact of the government's debt restructure arrangements with the bank. Concerned me, not so much because of the banks, but because of what the banks are likely to do as a result of the negative impact upon their finances. Because, Mr. Speaker, that reaction on the part of the bank is likely to ensnare yourself and is likely to ensnare myself and to impact upon our pockets. The point being, the point being made here is that dysfunction at the level of the courts is like an axe striking at the heart of justice, which of itself lies at the heart of our political, social, and human development, Mr. Speaker. Now, this is an issue of productivity. The honourable member for St. Peter didn't use the term productivity, but in essence, I thought that that is what he was saying. When you address the matter of delays, for whatever reason, in the judicial system, when you introduce a stipulation which says the standard is that we should have decisions fully rendered in 6 months, you're addressing the issue of productivity. We may not want to think about it in those terms because we're talking about the judiciary. But it is, how productive are you in the circumstances in which you pursue your obligations and with reference to how much you are paid and what privileges you enjoy. So we are talking about the business of productivity. Productivity is not only about economic input. It is about the rate, the pace at which the systems that manage our endeavors from day to day, those systems are able to respond to the demands placed upon it and the expectations also that lie at its doorstep. And so the court must see itself in those terms as well, that we must produce adequately and sufficiently at a rate, at a pace that we can responsibly react to the demands which are placed at the doorstep. Prime Minister made reference to the increased costs to parties, and am I reading upon this? That is especially with reference to civil matters, and she illustrated that in a fairly detailed fashion. But private parties are negatively impacted and disadvantaged by this. Business interests are negatively impacted by this. Investment is thrown off or stymied as a result of this. And you could create, as a result of this phenomenon, if it is an inordinate systemic delay process, you can create a very negative culture, impacting in the wrong way upon the mindset of those who otherwise would seek to invest in our fair land and in our economy. And so this matter is very important. It must be looked at in this very broad context and not in the narrow frame in which some would choose perhaps to look at it. Having said that, of course, Mr. Speaker, there's a continuing issue of the management of caseloads and the recent attempts to increase the number of judges, I presume, is a response to the argument which might be put by some in defense of the status quo, that the caseload is too heavy for the numbers of those at whose hands we expect the dispense of justice. So it's a question of manageable caseloads, poor administrative support systems. We have heard that argument put as well. Only do I make reference to that to suggest that if we add this stipulation for potential removal of the judges, it is, of course, our responsibility to ensure that there are adequate support administrative systems around those who are in the front line of doing this job. You can't tell a man do it in 6 months when the context in which that man, or woman I should add, perhaps even more particularly so, the context is such that there's not the adequate administrative and support mechanisms that would facilitate that rate of production or productivity And of course, integration of technology in the system also becomes an issue which must be of priority focus. The system has to be properly technologically platformed, properly staffed, efficiently so that it may produce as we expect and anticipate that it will. There are some inefficiencies in the registry department. I hear escaping the lips of those who are involved in legal practice that there's a high level of frustration. And we have to admit, as I understand it, I don't work over there, and I rely very much upon those who are operating in the immediate context, who experience these things from day to day, who would speak to me, or as my honorable friend from St. Peter would know, the voices at the top of Broad Street or the middle of the Swan Street. So, and I hear that there's some high levels of frustration escaping the lips of those who practice before the bar because of inefficiencies in the registry department, which have even further deteriorated in the face of recent layoffs. Now, I say these things, I don't say these things to get at the government. I say these things in a debate to point to realities that we have to consider and which must be addressed. And you cannot think that we expend fullest effort in addressing our inadequacies and inefficiencies in the system. We cannot think that we expend fullest effort in addressing the inadequacies and efficiencies in the system, while at the same time there is a program of layoffs that is impacting the system with respect to critical staff complement in key places, and the judiciary is one of those places. The registry department, as I am told, is one of those places, Mr. Speaker. Of course, to balance the discussion, you have to admit that it takes a long time to call some cases. My information is, Mr. Speaker, that some of the delay is not only on the side of the prosecution, on the side of the government bureaucracy that must service the judiciary, but on the side of some practitioners before the bar, none of whom are known to you, Mr. Speaker, and certainly you have not been identified as one who's given to such practice, and I applaud you for your sense of discipline, and I encourage you to continue to provide that type of model behavior before your peers. But just to present the balance, I understand that that is also a part of the mix. Now, specifically, Mr. Speaker, in our context, when it comes to the removal of a judge, I think we provide that it is for inability to discharge the functions of his office, arising, and this is in part, arising from infirmity of mind or body or any other cause. I suppose that might mean any other cause that is conducing to that infirmity of mind or body. But that is the Barbados position, to which we now want to add this 6-month prescription. I did a bit of checking, and in places far afield, Gibraltar, the case of the Chief Justice in 2009, removal can be justified where the shortcomings of the judge are so serious as to destroy confidence in that judge's ability to properly perform the judicial function. And I think you want to have officers presiding in our courts who can demonstrate a level of competence such that there is no peril or jeopardy to the confidence of the public in that ability so to perform. New Zealand, Mr. Speaker, for them it is about confidence as well in the judge's ability properly to perform the judicial function, where one would have to interpret what that means to oneself, to properly perform the judicial function. What does it mean that you're so serious, that it is so serious a deficiency in practice that you destroy the competence, the confidence of the public in the ability of the judge. In Switzerland, and I used to read when I would visit there in a former life with some frequency. I used to read a lot of literature because I have a lot of time on my hand. I'm not, when I go a certain place, I'm not the walkabout, run around type. So I stay indoors a lot, read when I'm not otherwise engaged. In Switzerland, is question of misconduct interpreted as willful or gross negligence in the performance of official duties. Misconduct interpreted as willful or gross negligence in the performance of official duties. We therefore, I suppose, would have to determine that if a judge is unable to render a decision in 6 months, should that be interpreted as willful or gross negligence in the performance of his or her official duties. And it speaks further to an insufficiency of performance which is permanent or which constitutes a pattern. And then the question has to be the issue of pattern, the issue of practice, the issue of habit. Is this particular judicial officer given to this type of practice? Does it constitute a pattern of behavior which further constitutes a cause for concern and hence removal from office? Now, since we have been going into all of these judicial and legal debates, and I might, Mr. Speaker, join you at the bar one of these days, when I might join you at the bar. I might join you at the bar. I say that in all seriousness, Mr. Speaker. You know, my ambition was to become an attorney at law when I finished college, and the Lord called me to the ministry. I chose that path. I have no regret. I have no regret. But that instinct is still there. And I might join you one of these days because I hear my honorable colleagues in here have plans for me in terms of my dismissal from St. Michael West. So I might have time to let them come. Mr. Speaker, let them come. You let them come. I might have time to join you at the bar. But I've been reading a lot about these Latimer House principles and Latimer House precepts. Something I honestly did not read about before we got into all of these debates relative to law and judicial practice and so forth. And those principles throw up also the business of incapacity and misconduct as constituting proper grounds for removal. Now, incompetence elsewhere is understood to be in a particular manifestation. Incompetence is considered to be a particular manifestation of incapacity and misconduct. So it would seem to me, Mr. Speaker, that from whatever perspective you come at this thing, the business of removal of a judge for a failure to render a decision in a given sufficient time does in fact constitute a proper ground for considering his removal once the method of removal is established in a proper fashion. But then we collide with the notion of the independence of the judiciary, because it is the legislature here, and this process would have started at the level of the executive in the cabinet, but it is the legislature here which will put in place this stipulation, which will be binding on those who practice at the bench at the level of our high courts. Now, The view is offered that the notion of judicial independence cannot preclude the ability for there to be a check on the judiciary by this branch of government. The fact that there is provided for a mechanism of check, I don't even want to use the word control because that conjures up the wrong type of image, but there's nothing that precludes an appreciation for the independence of the judiciary. There's nothing that precludes that in this particular branch of the government providing for checks and balances with respect to how the judiciary functions. The important issue would be that such check mechanisms are free of political partisan flavor. Free of political partisan flavor. Having read the proposed bill before us, it would seem to me that we are providing a mechanism for removal with this added stipulation. This is new, this is added, but that we are not departing from that framework within which the procedure to effect that removal is anyway brought more so into the realm, the arena of partisan influence, because we are still providing for a fairly non-partisan way of triggering the procedure and managing the procedure. Justice Telford Georges, of whom I'm sure you would be familiar, says that judicial independence is defined in terms of the absence of domination by the executive, the political functionary. And I think, having read stipulations in this bill, having read the constitutional provisions for appointment and removal of judges, this measure does not bring us to a place where it provides for a dominance of the executive or the legislature over the judiciary. And so with the measure, therefore, Mr. Speaker, I have no discomfort.
Honourable Member for St. Michael, West Central.
Thank you, Mr. Speaker. I rise too to support the constitutional amendment bill before this chamber. And I want to begin too by saying that the Barbados Labour Party, for years, going back to the days of the Right Excellence Granley Adams, had a very proud and successful record advocating on behalf of the workers of Barbados. And I believe that's the point that the Honourable Member for St. Peter in his presentation today stressed on. So I just wanted to make that, as you go back to the annals of history and you come through, you will see that the Barbados Labour Party, and it continued through successive Barbados Labour Party administrations. But Mr. Speaker, I support the amendment because it is, especially as it relates to the judiciary, it is an attempt, sir, to enhance the efficiency of the judiciary. And that is good, and it's ideal, and I would say a wonderful goal for any progressive government. They're well paid, well compensated, I would add. Excellent retirement packages, in fact, better retirement packages than people who serve in this chamber. And I also believe that as they continue to do the job assigned to them, that it would help us in Barbados to also improve our ratings in reference to the ease of doing business in Barbados. The speed of the judiciary, sir, will certainly engender confidence in our system, and as we continue to improve the confidence in respect of doing business in Barbados, I think it is a wonderful start. Mr. Speaker, I also support the establishment of the composition of the Administrative General and Professional Service Commission, as well as the Protective Services Commission. I believe it was in the Constitutional Review Commission, chaired by that honorable and wonderful gentleman who also served as patron of an organization that my grandfather had the honor to lead, known as the Dorcas League. I refer to, sir, and with your permission, Sir Henry de Boulay Ford, a wonderful man indeed. Sir, and I took the opportunity only last Saturday to review the work of the commission as contained in that document. I believe it's about 120 pages. And within that document, reference was made to the Protective Services Commission. And I believe that was back in 1998. I stand corrected. I believe it's in 1998. And that commission, that report, sir, is required reading not only for us as politicians, but I also believe it's required reading for all those who are aspiring to someday into this chamber and who want to have an understanding. I believe that, and I believe the honorable member for St. Michael Northeast made the point that over time we will have a fuller debate on the Constitution and any amendments thereto. But there are some things within that Constitution, not only the Protective Services Commission, but matters reference to adoption of children and so on, that we really need to have a discussion and debate along other issues. Mr. Speaker, what was envisaged, in my opinion, back in 1966, and worked well during that era, sir, cannot be applicable to a modern Barbados in 2019. And why do I say that, sir? Because we have a Public Service Commission. It was established, as we've become accustomed to know, that it was a mechanism to avoid political interference. And so it is alleged. And that the executive should have little or no input in that aspect of the public service. Mr. Speaker, I don't know and I do not understand how any chief executive officer of any executive branch of anything, sir, could not have and should not have at least key input on managerial appointments. I do not understand what it'd be like, sir, and I work in the private sectors, you know, that if I were in charge of a company, if I were an executive of a company, that you could have little or no input in the executive management. That is something that we don't have to address now, but I've come here to advocate change. And it's something that we have to think about, and it's something I think we have to start to look at in terms of reforms. And Mr. Speaker, you'll probably ask why I say that. Because, you know, I'm not a minister of government, but they're ministers, sir, of government. And when things are broken or when things go wrong, they have to take responsibility, because the public will say, the minister. They look to the executive, Mr. Speaker. They don't look elsewhere. And sometimes the poor minister, the political class, in other words, sir, would have to sometimes suffer a dent in their popularity, because the public would believe that is something that the minister did when the minister had absolutely no control, sir. But that is perhaps something that we can discuss or should discuss later on. And I hope that these challenges are addressed. But I want to say, sir, that we should never have a situation in this country when the executive, for example, when there's a change in government, that, you know, commissioners perhaps can elect not to resign, and that they can continue. And therefore, if you were faced with what we were faced with before, it sends the wrong signal. And I believe, sir, those challenges could be addressed later on. But I believe, sir, if you are sitting on the commission and there's a change of government, if you were not appointed, and I understand the appointments through the other branch, that you should automatically tender your resignation, or there should be some safe clause within legislation to allow those who serve to put their resignations at the disposal of the government. I mean, Mr. Speaker, well, in other places, that's basic governance. Very basic governance, sir. And I don't believe that an executive should be held ransom. Never, sir. We should have a system in place to address those concerns. But I believe that will be addressed sometime down the road. Mr. Speaker, I support the need for reform, but I also will say that we need to have support staff within the Personnel Administration Division. We need strong HR management and systems and standard operating procedures, sir. We need to expand the HR function within the public sector of Barbados. We have, I am aware, a personnel officer. But again, that is a practice, sir, that perhaps served us well back in the 1960s. Those days are long gone, sir. We need to come back. We need to get to a position of currency and move to the future. And we need to have a HR management function within the public sector, not a personnel management function. There's a difference, a huge difference, sir. And I believe that if we move away from a personal administrative system to more of an HR management system, I think it would do us well down the road. Mr. Speaker, it is true that we need to also look at reviewing the duties, and this has to be part of comprehensive reform. And I agree that you will have to get all the stakeholders together to discuss these matters. But we need to have a review of the duties entrusted to Personnel Administration Division and go through them, because you need to have good HR practices. We have very good HR practitioners in Barbados. We have strong labor union representatives in Barbados as well. And perhaps the time has come where you can put those together and sit down and look at how best we can fine-tune the HR management in the public service to enhance efficiency, sir. And I believe that from my heart. But I will also say, sir, and I said it in the budget, that we need to repeal the qualification order of 2016, Mr. Speaker. Everywhere I go, and you know, Mr. Speaker, I canvass. Up to yesterday, sir, I was in Rogers Quarry Road, First Avenue, Gazette Road, and I also did Darriston. And while I'm in Darriston, I'll ask the Minister of Public Works to look at the road down there for me. Mr. Speaker, up to yesterday, and everywhere I go, sir, there are people from within my constituency and outside of the constituency who would call me and express dissatisfaction. And Mr. Speaker, if I have to speak in here every Tuesday about the qualification order of 2016, I'm going to do so, because the last administration did an injustice to a lot of people in the public sector of Barbados, sir. And we have to deal with it. You cannot have a situation where the people who have experience within the sector, but because they don't have the qualifications, sir, that they have to remain at the bottom of the rung of the ladder, sir, and other persons can go, and they too have to in turn train the staff. So, Mr. Speaker, we need to review it. We need to review it. The issue of letters of appointment, sir, within the public sector, that is a common complaint. People complain to me all the time. So we need to move. We need to move away, sir, and become more efficient in respect of that. The issue, sir, of notification as it relates to movements from movements within jobs, sir, within the public sector. Mr. Speaker, sometimes people tell me sometimes they get 1 day's notice. They're told today, you report elsewhere tomorrow. Mr. Speaker, even if you have a mobility clause in your contract, you at least get a reasonable notice, sir, within contracts of employment. And that is something we have to look at, sir. It is unacceptable. You have a situation, Mr. Speaker, where you have an employee who perhaps with a special skill working within the department. And then that employee, 1 day's notice, sir, is transferred with that special skill and moved to another area. And then the department then is scrambling to seek another resource. Sometimes you don't get the replacement resource for weeks. Mr. Speaker, you can't run and talk about efficiency if we don't fix these things. We have to, Mr. Speaker. And that's why making the case, perhaps to have experienced HR persons, labor unions, etc., to help us resolve some of these issues. The issue, Mr. Speaker, of acting appointments as well. Too long, Mr. Speaker. You have persons, I am aware of persons who are acting in positions for more than 12 years. Dangerous for the worker too, because tomorrow they could be sent back to their position and another person come, not appointed by the political class, not appointed by the executive as we know it, but appointed maybe by the commission. And Mr. Speaker, that's another story that I intend to speak to sometime too. Because the workers also told me, and that's why I made the point, it is alleged. Because you know, sometimes you might have a family or a friend, not the political class, but the political class will take the blame. But we cannot have a situation where you have acting appointments going on. I know of one case for 12 years, in fact more than one, sir, where the persons have been acting for more than 12 years. And we have to address these issues. And if the last retrenchment exercise didn't tell us anything, Mr. Speaker, I think we should remember how it was done and how we manage it, sir. And that is all I will say on that point. The issue, sir, of discipline, we have to find a more efficient system. You cannot have a public servant on suspension for years and just obviously on full salary. Some people have salary, sir. But the issue is this: it is a cost to the government. It is a cost to us, the taxpayers of Barbados. So if you have some person at home on suspension pending investigation and you keep that person at home for years, the system is wrong, sir. We've got to look at these things and we've got to move with great haste, sir, to address these issues. Mr. Speaker, I wish to suggest, recommend, that we start looking at an integrated HR management system for the public sector of Barbados. Why do I say it, sir? You need to have an HR management system in place. I'm not saying they don't have one in place, sir, but I think they need to have, based on my experiences, based on what I'm hearing, you need to have a proper HR management system in place. Mr. Speaker, it would help the country address the issue of efficiency, but more importantly, sir, you could have a career management system in place which would take care of a lot of the issues that I cited in my presentation as it relates to the movement of people within jobs. A simple career, I call it simple, sir, but a career management system. I believe they have a payroll system, and if they have a central payroll system, that should be integrated into a central HR administration system, so that issues of persons who are acting, sir, and have to wait for months to be paid could be addressed. The issue of temporary workers who have to wait on a PAD and other people to sign all these forms, sir, you could easily manage the system so that you don't have to be a worker within the public sector and that you have to wait from 4 and 5 months before you are paid. I mean, it sends the wrong signal. If anybody in the private sector had done that, you would have heard the entire country complaining, Mr. Speaker. And what is good for the private sector has to be good for the public sector, Mr. Speaker. It is about a standard. It is about a standard performance. You cannot have a system in Barbados where you have doctors who have mobility, nurses who have mobility, especially if you're RN. You can pick up and go to America, Canada, wherever, earn more money. And you keep them waiting for months, sir, to be paid? Well, they too have responsibilities. They may have a rent or mortgage to pay, children to support, have to support themselves, Mr. Speaker. It is unacceptable, sir. And I would suggest that they have a new HR management system, sir. But we have to move away from what we refer to as personnel function and take it to an all-inclusive human resource management function. Mr. Speaker, the Honourable Member St. Peter, he knows about human resource management. And he is in the Ministry of Labour. And I know that he will use his good offices, sir, and his intelligence, sir, his intellect, to assist, sir. And I really and truly believe that we need to do this. We also have, Mr. Speaker, a wonderful opportunity if it is integrated with the other HR departments within government, because you have personnel departments almost at every ministry. And what obtained with the last retrenchment exercise, where the PAD had maybe one date of employment, and then you have a department within a ministry saying, well, no, this is the date of hire. So you have to have one date of hire. So if you have a central system integrated and linked to the ministry, sir, I think it will help us so that the challenges, I don't want to go into detail about the last retrenchment exercise, some of those challenges could have been managed and eliminated, sir. That is my view. Sir, if we modernize the HR function, like I said, there will be substantial benefits to the country, including efficiency, productivity, call it whatever you like, sir. There will be significant improvements. Mr. Speaker, we have to reduce the burden of frustration. And that is what happens, sir. Because when I hear workers who work in the public service come to me and they're complaining because they're frustrated. They enjoy working in the service, but they will like key aspects to be fixed. So that, Mr. Speaker, I support the amendment. There will be expansion of the service, shall consist of a chairman and not less than 4 nor more than 8 other members. Mr. Speaker, I salute that, sir. But I too, sir, would hope that they have targets too. And that we also look, especially as it relates to discipline, a new mechanism, a procedure, sir, that could dispense disciplinary hearings within a defined period. If the judges have to subject themselves to 6 months, then I don't know. But we have to come up with, some people may argue we need some service guarantees in this country. I don't know. But perhaps we have to look at that. So, Mr. Speaker, I'm not going to delay the chamber because I am mindful of the time, sir, and I cannot offend the Speaker, sir, in respect of my time. But I really am calling for the comprehensive reform of human resource management within the public sector. We got to move away from personal administration to central human resource. And there are good people who work in the public sector. They're very good people. But it's a system, sir, that over time that we continue. And we've got to change, sir. And I referenced my presentation earlier when I commenced. I said, what perhaps served us well in 1966, sir, perhaps is antiquated now. And we need to seek and move to systems relevant for the times, Mr. Speaker. So I know I've said a lot, sir, but I really have to speak to this issue. And sometime I'm going to come back and speak to the issue. But I really want to make representation on behalf of those who sent me here, some of those who sent me here, sir, for us to improve the system. But, Mr. Speaker, I will end on this note by repeating myself. I really think the government should consider repealing that qualification order of 2016, sir. Mr. Speaker, I can speak and I can continue to speak in here every session if necessary, sir. It has to go. It must go, Mr. Speaker. It is frustrating, sir, and demoralizing the public service of Barbados. And there are a lot of people out there who agree with me. And there are a lot of people there who are hurting as a result, Mr. Speaker. I never gave you permission to call the names of people in this debate, so I can't tell you the names of constituents, sir, who have come to me. I can't do it, sir. No. But I will never do it. But the issue is we have got to repeat it. So, Mr. Speaker, I support the amendment, but I'm also asking the government to consider, as I know this Progressive Barbados Labour Party will do, look at modernizing, reforming, and moving to a central HR platform within the central government of Barbados. In statutory corporations, you already have HR managers. Link it so we can create a wonderful apparatus to reduce frustration and to increase worker morale within the public sector. Mr. Speaker, I'm much obliged.
Honourable Member City of Bridgetown.
Mr. Speaker, I'd like to move the suspension of the sitting for dinner until 8:10 p.m.
The question is that this honourable chair will be suspended until 8:10 p.m. All those honourable members in favor, please say aye. Those against, please say no. Meeting the ayes have it. This honourable chair stands suspended until 8:10 p.m.